So I'll let the panelists briefly introduce themselves, but I'm Berin Szoka from TechFreedom. Colleen?
Colleen Chien. I'm a visiting professor at Columbia Law School, and my home institution is Santa Clara Law School, and I served in the Obama administration in OSTP from 2013 to 2015, working on innovation and intellectual property.
I'm Radia, Senior Policy Counsel with Lincoln Network.
Adam Thierer, Senior Research Fellow, Mercatus Center at George Mason University.
So we're talking about the future of governance today. I wanted to lay out a few themes, and then we'll ask our panelists how they intersect. Adam's written a lot over the years. Adam and I used to work together on the theme of permissionless innovation, the question of how much freedom innovators get to decide how they're going to do things in an unknown future. So that's one question of who decides as between the innovator and the government. Ryan and I have been focused a lot more in recent years on the question of who decides within government. Is it the federal government or is it state actors? And within the federal government, is it the democratic elected lawmakers in Congress, or is it regulatory agencies? And if it is regulatory agencies, how much freedom of action do they get? What sort of scrutiny do the courts impose upon them? So another two layers of who decides. Colleen's work is very focused on the question of how do regulators decide? What sort of how do they test their methods? And I'll ask her about whether there's a role for people on the outside of the administration or government to be involved in policy making. The Obama administration actually said a lot of really good things about that from my perspective. 2012 Privacy Bill of Rights, for instance, noted that it was really very difficult for regulators to figure out hard issues like privacy, and that really ultimately they recognized you would need to rely upon people outside the government, multi-stakeholder bodies, or other sorts of standard settings groups, or people who made codes of conduct, to work out these hard questions, because they alone had the flexibility and the resources to decide these issues, and the government's role might be to regulate. So those are some of the themes we want to talk about today. I want to start with Adam. Adam, you've written about permissionless innovation for years. What do you mean, and do you think that's on the upswing or in retreat?
Sure, thanks. First of all, thanks to Garrett and Zach for inviting me here today to talk, and congratulations to Lincoln for all the great things they've been doing and the conferences like this they've been hosting. So when you think about the big picture of the governance of technologies going forward, and in the past, in fact, you end up finding that there are generally sort of two conflicting worldviews, a conflict of visions, if you will, between two different types of paradigms. One would be a traditional sort of precautionary cast, a precautionary principally oriented kind of regulatory mindset that says that generally speaking innovation should be held back, slowed, or even stopped until its creators can prove that there is no potential risk or harm that could come about from the new technologies. The other vision or paradigm could be called permissionless innovation, a term I should note that I did not coin. I don't know who coined it. If any of you do, please let me know. But I've written a book to try to help popularize it as a policy vision. And generally speaking, permissionless innovation stands for the proposition that innovators should be given the green light, that they should be innocent until proven guilty, and that we should allow for experimentation with new types of technologies and business models until such time as critics can prove that there are actually some substantive harms associated with said technology. So that's the general sort of high-level worldview of the two visions. Which one's winning or losing? It's a give and take. We're never absolutely at permissionless innovation or a precautionary principle kind of vision in any sector. There's always a fluidity along a spectrum, but clearly some sectors are more governed by precautionary types of approaches than others, and sometimes rightfully so, whether it's aviation, pharmaceuticals, fintech, so on and so forth. Whereas others like the internet or emerging technologies like VR and AR and 3D printing are more in the permissionless innovation camp, and there's always this battle between the visions.
Adam, how do you interpret the techlash? Do you not see that as a political blowback against the culture of permissionless innovation that the Clinton administration pioneered, that has dominated the internet? I mean, it's very marked that until a few years ago, we had members of Congress from both sides of the aisle falling over themselves to show who could be more pro-tech, who could talk about innovation and freedom to tinker more, and now we are talking about sending innovators and corporate executives at tech companies to jail.
Yeah, that's right. I think there's always these sort of waves of sort of techno-panic waves that you see, and the techlash is just indicative of this. We've seen it in many other sectors and for many other technologies throughout history, that after sort of a honeymoon period with any technology or sector, there's a sort of blowback and a lot of public backlash and even some corresponding regulation. And we're certainly seeing that for the digital tech sector today. Whether or not it sticks, what it means substantively is a little bit unclear to me still, just because there's a lot of huffing and puffing and a lot of panic about these technologies or sectors. It's not really clear what it's going to translate into policy-wise, at least here in the States. We see what it looks like in Europe and in other countries. But I'm still optimistic, if for no other reason that I'm a big believer that one person's quote-unquote pacing problem is another person's pacing benefit, that technology evolves linearly or exponentially while public policy evolves incrementally, and the gap between them tends to grow. So technology's going to be continuing to accelerate pretty rapidly along, and it'll be hard for governance to catch up in many cases.
So, Colleen, there seems to be a certain parallel between Adam's argument that we should allow room for experimentation in the private sector and your view of the way the public sector should operate in a similarly more experimental way. Do you see a parallel? What is your vision for experimentation in governance?
Yeah, I mean, I think I want to shift the conversation a little bit away from policy for innovation to how do we actually think about innovation and using innovative methods to form policy. So if we think about, the things that have really worked and have taken in recent years, if you think about your digital engagement and how everyone's checking their phones and we're all sort of using technology in a totally different way, the reason that is because of relentless, rigorous testing, right? Every time you get an email from a large group, it's probably you're getting one of several variants of the email. They're measuring your response and they're tailoring their actions accordingly. And that's why we are all engaged in new content, receiving new kinds of media. Every time you're watching Netflix or on YouTube, an algorithm is observing what you're doing based on what you did before, using AI to then develop another recommendation. But when you do or do not engage, that data is being taken back to refine what's happening. And the idea is to really think about how can we make policy in the same way? Can we actually make policy with deliberate ideas about what we are trying to achieve, what the point of the policy is, and actually try to rigorously measure that and figure that out. So I'm happy to talk more about that idea, but there are a lot of obstacles. I feel like there are a lot of people in government who really want to try to fill these information deficits of what is and what isn't working. The private sector can certainly be a huge part of helping that take place, but there also is a lot of unease around how do you actually experiment, how do you do rigorous testing, is it fair to give a waiver to some companies but not to others and test how that comes out, how do we actually measure over the long term. We've had a huge problem with data, I think, for a long time because you might say, well, we want to try this new housing program and see if it actually helps people on the lower income come up and get through the ladder of prosperity. Well, to actually do that, you need income data, you need the kind of gathering of a lot of information over time. And it's only been slowly over the last, I would say, decade with opening of government data that we've been able to federate these data sets. We can actually now track outcomes in the same way that private companies can. So I've been looking at all the different kind of pockets of excellence within the federal government to do experimentation. We have now these policy labs that are being developed at the state level. You have the World Economic Forum working on sort of agile government. So I think in general you have more and more interventions. A lot of them are on the, I would say, behavioral side in terms of just RCT, so A/B testing around, should we send this form or that? But going up the chain into actually, let's try this policy on one set of folks and not on another, and just see if actually that works out. And it could be a small set or a larger one, but I'm happy to talk about that more as an idea.
I'm hearing two different themes. One about that A/B testing and the idea of being able to treat different parties differently, which is a difficult issue for administrative law and constitutional reasons.
Yeah, the constitutional, yeah.
Yeah, so let's come back to that. But the other idea I hear you talking about a lot is the really key role of information in all of this. The other thing that I like most about the Obama administration approach to regulatory policy was the work that came out of OIRA under Cass Sunstein. OIRA is he was the regulatory czar for the Obama administration. And he wrote a lot about how we need better data and how we should, if at all possible, we should start the first layer of regulatory response should be in requiring smart disclosure, requiring companies to make information public or at least available to the government, instead of trying to regulate their behavior. So how does that fit into your vision? And that hasn't really gone very far, unfortunately, but do you see that vision of regulation, a lighter touch regulation, having a future?
Yeah, I mean, I think it's a new kind of modality to think about the best information of how things aren't working, or it exists, but it's not easy to get it. So if it's in the private sector, it's trying to create ways for that information to flow back and forth. So there is a new bill or a new law that was passed. I think it was maybe passed in the fall, but the president signed it into law in January, called the Evidence Act, and it's come out of a multi-year effort of the Commission for Evidence-Based Policy, bipartisan group that's really said we have these informational deficits. That's why we're spending money on stuff that doesn't work. We're not taking these we're making type 2 errors and not developing policies that do work. And
type 2 error is
type 2 error, the idea that we could be making changes in the government that would actually benefit the mission, but in many cases we're not doing it because we're scared of sort of the blowback. And the best example might be FDA thinking about their mission. They only get punished when they make a mistake to allow something that is not that ends up being a bad drug, right? So they're afraid if they regulate or allow a drug to be released too early, that it has negative consequences. They aren't rewarded for bringing a drug to market quickly, right? So that's a type 2 error. If they're bringing things to market too slowly because they're more worried about the blowback.
So how do we create those reward mechanisms inside government?
So yeah, I think that's part of the issue is we create a greater capacity for failure, for experimentation, where you're going to try stuff, it's not going to work. If you look at experimentation in the private sector, whether it be Facebook or Google, or even some of the government experiments that have been done by IES in the after No Child Left Behind, that was their sort of rigorous evaluation shop. 90% of interventions were failures, and we're continuing to spend money in the government on programs that may not be working, and not trying to figure out what actually would work, and that's where I think we need to move.
Well, I want to bring Adam in here, but just one question first. So quick anecdote. Last summer, I testified before the Federal Elections Commission.
Mm-hmm.
There's an issue there about how to deal with the disclosure requirements for political ads in the context of internet ads. And for many internet ads, you can't do it. They don't fit. How can you put them in a tweet or some smaller format? And so some people are talking about effectively banning those small ads because the disclosure won't work. And so I went in and I said, look, this is crazy. Why don't you just require that the disclosure information, who paid for the ad, what's their website, how do you find them, et cetera, why don't you just embed that in the machine-readable text that is served up along with the ad, so it doesn't have to be displayed on the face of the ad, but it can be parsed by user agents like browsers or browser extensions and so on. And this is an elegant solution, I think, to the problem. How do you get that information out there? The League of Women Voters could have all their members with a browser extension to view that information. You could track, who's showing ads out there. And it would allow you to not ban this form of advertising, right? You get the information out there, and they didn't get it. It was so foreign to them that this idea, which, of course, people in government have been talking about for years, Lessig has been talking about for 20 years in the context of P3P for privacy. And it just made clear to me that there is such a huge gap at every federal agency of trying to get them to think about more innovative solutions than simply banning a particular practice and to just make more information available. How do you penetrate that lack of sophistication?
Yeah, so I think agencies, certain agencies are starting to do that more. So I would mention used to be called the CFPB, now it's called the Bureau. They actually had, sort of an open RFC, which said, pitch a pilot towards us. We have this regulatory mission. You can tell us actually how we should experiment to actually do a better job in what we're doing. So you can have these open channels of discussion and conversation where they say, this is what we're trying to achieve. Going back to your earlier point of rather than regulating the activity, regulate the or give us the data. We want to get to some kind of success-based governance or results-based governance. We want to form the policy in a way where we're specifying the outcome. We're not specifying the way you get there, right? Sort of what you were talking about earlier. I think there are some agencies and there are other RFCs that are out there that are saying, we invite you to collaborate with us and to give us some ideas about how to do things. Now, if you can generate some hard data, showing that model, you had an idea there, but could you actually, going from ideas to implementation, could you actually build a system and pilot test it and do it on a small population or some sort of, portion of Twitter? So I don't know how you would actually do it, but could you produce some results that actually would change their thinking, right? I mean, you saying an idea itself, also comes with there's a lot of uncertainty that just comes with, you're saying, if they're saying, well, no, we just don't know how to do it, you're saying, well, this is a way, to expect them to then just adopt your way is also, pretty is a pretty significant step, right?
And in fact,
because you think about how products are made, they're prototyped, they're tested.
Well,
So how do we
that
bring
was
this
exactly my
prototype
argument, was
right.
at least try this for the next election cycle. You'll collect data because, anyone can track all of these ads that have this disclosure, and then we can see how things go. And they're still arguing over what to do.
Right, and so I don't know if in the meantime you can convince a small election to try it and, come up with this idea of trickle up. If we can get small experiments to actually generate some information and data, you can remove, can kind of like build out the whole list of things that could happen and provide that information.
Okay, so we'll come back to the federalism issue with Ryan, but for now, Colleen had on her laptop a sticker that says, "Move purposefully and fix things." Is that right?
Yeah.
Okay. Adam, is that in tension with your idea of permissionless innovation and the common mantra of moving fast and breaking things?
It doesn't have to be. It doesn't have to be. So look, what Colleen's talking about are forms of experimental governance, and they're part of a broader universe of what we might call entrepreneurial administration. And there's a lot of wonderful writing being done about this because there's a lot of wonderful actual innovation happening in the governance of emerging technologies today. I recently released a dreadfully boring 100-page law review article entitled Soft Law for Hard Problems, co-authored with Ryan Hageman right here and Jennifer Skees back there. It's in the Colorado Journal of Law and Technology, and it basically attempts to document what's happening on the ground in the real world for the governance of various types of emerging technologies, from driverless cars to drones to genetic testing to all of the other things we mentioned. And what we're witnessing is the emergence of very messy hybrid forms of governance that aren't pure permissionless innovation, but aren't pure precautionary principle. They're basically governments trying to respond to technological change and the nature of the pacing problem and permissionless innovation and evasive entrepreneurialism through an entrepreneurial administration approach. And that could include things like multi-stakeholder processes. It can include various types of sandboxes, as they're called. It can include guidances, various types of best practices, codes of conduct, self-regulation. There's a broad gamut of different types of governance schemes, many of which have existed for many, many decades in the administrative state, and which, by the way, are hated by both conservatives and liberals, but nonetheless widely utilized, and increasingly today, the primary mode of governing emerging technologies. We're not going to get pure permissionlessness. We're not going to get pure precautionary principle, except in a handful of circumstances. We're going to get something in the middle. And what I'm encouraged by, and what Ryan and Jennifer and I talk about in our law review article, is that this is yielding a lot of great innovation opportunities while also positively responding to various types of social concerns, privacy, safety, security, whatever else, related with various types of emerging technologies. I'll just give one example and then move on, because I know we got to get Ryan into this. But you look at what driverless cars is. I mean, we've been waiting for what now, 5-6 years for the Self-Drive Act and like legislation to happen on that front? Now, maybe we'd be in a better world with legislation, but it's not happening. What's happening? What filled that gap? Well, what the Obama administration did along with the Trump administration, and basically it's very similar, is they've come out with sort of like shiny, like glossy PowerPoint documents that are like undated with no page numbers that are essentially the law of the land. They even version them like software. So, driverless car guidance 1.0, 2.0, 3.0. And they're iterative. They come out every like 12 months or so. And they are not formal rules of the road, but they're guidance, they're informal types of rules. And I'd like to argue that's leaving a pretty good space for a lot of interesting innovation to happen, but also being responsive to things about like connected car cybersecurity, privacy in cars, various types of safety issues.
So, Ryan, as a lawyer, how uneasy does what Adam just described make you?
It's an uncertain area. I mean, we've seen how multi-stakeholder models can work in some cases, but the traditional governance approach of common law doctrines with government playing a central role when it should, which in many cases it shouldn't, is an approach that I'm more comfortable with. But if you'd like, I can talk about the question of who decides within government that you talked about at the beginning.
Yeah, no, let's unpack federalism in a second. But what Adam has just described is essentially a way to bypass all of administrative law. Which is really problematic and rigid, right? And it has a hard time keeping up with changing technological norms. But it was all done for, at least in principle, for good reasons, right? For wanting there to be due process to regulated parties, clear guidance to them before they are penalized. So, what do you think about essentially just creating this new, bespoke, improvised regulatory system?
So a concern is, and one we've seen in the past, is that these models can evolve in a response to governmental pressure, that the industry has to sort out this problem or else the government will get involved, where it's not a truly voluntary situation, and the result is that these entities that make decisions about how conduct occurs lack the things like due process and democratic accountability, but they still exert sufficiently broad power that they have a great deal of authority. We see this in the financial sector with self-regulatory organizations, which won't respond to FOIA requests. They don't go through Administrative Procedure Act rulemaking, yet they regulate de facto industries with implicit or in many cases explicit governmental authority. And so if the process that Adam describes can occur solely outside of traditional governance, where lawmakers aren't threatening that if the sector doesn't solve problems, legislation will occur, maybe then you can have ideal outcomes, because an innovator can always come up and start a business, create a new innovation outside of that sphere, with the implications maybe being that they're rebuffed by the existing players, but they can work outside of it. But if you have a situation where the soft law governance mechanism occupies the entire field, then that opportunity doesn't exist.
Okay, so Colleen talked a lot about experimentation and governance. The traditional American model for that, dating back to the Federalist Papers, is, of course, federalism, the idea that states can be a laboratory of democracy. Is that a good model here? Does it work in some technological circumstances but not others?
I think it does work in some technological circumstances where a new technology is predominantly affecting people locally, where it's not about connecting information and people across state lines or across international lines. There certainly can be a role for governance to occur at the state level, maybe in some cases at the level of a county or a city.
So scooters, Lyft.
Sure. Where if you're a right to leave scooters on sidewalks, maybe it's a decision that's best made by states, maybe by cities. Sure. With transportation networking companies, there's a role, I think, for local involvement to a much greater extent than there is with a lot of other aspects of internet-connected businesses. But the pendulum seems to be swinging in the direction of too much local and state control, where states are essentially occupying a gap that's been left because of the fact that the federal government, Congress, hasn't stepped in to either set federal standards or preempt the states from acting. We've seen a number of laws, including in the 90s, notably the intermediary liability provisions of Section 230, which say that state criminal laws and common law causes of action cannot hold intermediaries liable for being treated as the publisher of their users' conduct. We see some preemption in the telecommunications space, but in a lot of spaces, like notably privacy, for example, we don't see the federal government having a role that prevents the states from doing what they want. And so increasingly states, notably California, but others, are stepping in to fill that void in a way that may finally cause Congress to act, perhaps not in the way that would be optimal and in a way that's the result of pressure. But the growing willingness of states to get involved in this space is troubling for a number of reasons. Democratic reasons, in terms of the ability of one state to extend its will to effectively the entire nation, especially if it's a particularly important state, and the limitations of how the decision-making process works at the state level, where the Madisonian factions that compete at the federal level don't exist with the same vigor at the state level, resulting in outcomes that don't reflect the participation of those who are regulated, and consumers and innovators and other individuals who care about the issues to the same extent that occurs when Congress or even a regulatory agency thinks about an issue.
Yeah, my big pet peeve in all that is people who talk about a patchwork. Like anytime states are regulating, they say, oh, it's a patchwork. Well, it's a patchwork if state laws apply. If you have 50 different state laws within each state. Once you have one law that regulates everyone, that's no longer a patchwork. People don't think about these visual images. A patchwork is, California has its rules for California. For privacy, however, we're talking about California regulating the entire internet. That's more of what we've called a layered cake. You could have 50 different layers of regulation that everyone has to apply for everyone if you can't distinguish where people are coming from or limit, as you say, services into one state. Colleen is looking at me incredulously.
I'm just saying the problem is that people actually like cake. So maybe we should come up with a different.
Can you think of a better?
I mean, maybe you think like the large patch, which is sort of engulfing everything else, like a cancer. I mean, you can talk about it maybe that way. I just think people like cake.
Or in a Halloween special way, the cake is also cursed. Adam.
Okay.
So look, my 9 boring books was on federalism, interstate commerce, and the technological age. Nobody's ever read it, but it was 98. And, I've been struggling with these issues my whole life. But I am still a defender of the idea of state experimentation as sort of, honest to God, laboratories of democracy and what we often call like innovation zones. We've been talking about charter cities and like innovation hubs. This is what states are supposed to do. And sometimes it works, sometimes it doesn't. But I think you have some pretty positive success stories out there. Look what Arizona's been doing to create more of an innovation hub on fintech and driverless cars, and recently passed some really far-reaching occupational licensing reform legislation. Governor Ducey down there has opened up his markets, and we live in a world of innovation arbitrage. Innovators increasingly move around to the jurisdictions that treat them most hospitably. We see this both at the domestic level, the city level, and even at the international level. Now, of course, there are times, Berin, as you suggested, when things go too far, and it often comes down to the California problem, to which the ultimate solution is break up California. My old colleague Wayne Cruz used to say we need to divide California north and south and then let them go to war over intellectual property, and the Civil War would stop all their bad laws, but I don't know. The point is that, yes, there is a California problem, and that does lead to the concern about the need for preemption, and sometimes we get there. We've gotten there in the past on things like when California tried to have a sort of like food labeling law of its own kind of thing. We've had that with GMOs most recently, and, there will need to be some level of preemption, but we ought to give experimentation a chance. And I work at an institution with a bunch of PhD economists who don't agree with me on this. They look at states as like barriers to, efficiency. But there are also, opportunities. There are chances for us to learn and have the kind of experiments that Colleen mentioned. And not all of them are going to work, but I actually think we should give some breathing room to them to do so.
Yeah, that's a good point, and I have read your book. I'm one of 2 people to have read it, other than your editor.
I gave it to you, though. You didn't buy it.
That's true. I
haven't bothered.
But there's a temptation to just pick a broad field of technology policy and sweep it away with a preemption provision that's very simple, or maybe hand it over to an agency to just do whatever it wants, right? Without actually thinking of maybe there are aspects of this issue that are best left to the states. And you've written about how there are some areas. If you're talking about building a fiber optic line across the country, it doesn't make sense for every state to be able to extract its rents. But so there is hard work to be done that often is overlooked when decisions are being made about whether the federal government should stop states from entering a space from a regulatory standpoint. And the issue you raised about states like Arizona creating opportunities for regulatory arbitrage is a good one, because it brings up the issue of whether the regulation is where the states can dictate how any company in the world, or at least in the United States, has to do business if it wants to serve their customers over the internet, versus does it only get to regulate the businesses that choose to have their principal place of business in the state, or at least have a strong physical nexus to the state. And there is a very good case to be made that if people in one state want to go on the internet, for example, and do business with a business in another state, and the only contacts that other business has is that it allows people from other states to communicate with consumers in that state, that's not something that every single state should be allowed to exercise its veto power on with respect to its consumers.
Ryan, can I just also ask you on privacy? You sort of talked about the problematic kind of model with California, where I happen to come from, the California law, and then also the sort of coercive nature or potentially of self-regulation in the shadow of federal regulation or state regulation, and how that's not going to be completely optimal either. So I don't know if do you think common law, what do you think should be the right revolution? Do you think Congress should just get its act together and really do a good job of getting all the parties in the room and really hammering it out, and that's where there should be action? Or do you believe that, common law is enough, we don't need regulation? What is your vision for privacy if you don't think, California, what's happened so far has been ideal? What would be the right way, kind of going back in time, or even kind of starting where we are now?
So I suppose just talking about the ideal model, I think a federal common law approach would be just fine. Revisiting law of doctrines and having a situation where we apply simple concepts. We try to modernize simple concepts of fraud and omission by deception or by misrepresentation.
So here's where I think I've found a problem. So I teach AI, and when I look at the lawsuits that are being brought, you have some standing and justiciability issues that arise. And it just makes it very difficult when you have this kind of aggregate harm that at an individual level makes it hard to have parties
Okay,
So I wanna ask
let
about
me
that.
interject
We can
here,
go there
but
later, but I do
we've
wanna
already
talk about
answered
that.
this question. This is what the Federal Trade Commission does, right? The Federal Trade Commission is there precisely because it's hard for private plaintiffs to establish standing and bring those cases, and it has essentially already been dealing with these common law ideas. So we don't need to, have some theoretical world in which we revive a federal common law. We already have decided that we're going to have federal consumer protection law, and on top of that, Congress has passed, in particular instances, in multiple cases, law that in my view, is effectively a codification or a refinement of what the FTC either maybe could have done on its own or would have been just beyond the bounds of its authority. So we've done this with children's privacy and credit reporting and various forms of discrimination, and that's what we should do with privacy, right? We should have a federal law that, just like all those others, builds upon those basic ideas and might say, for example, when we talked about opt-in and opt-out, what we're really talking about is certain categories of things or things that that you would reasonably expect someone to tell you, and if they're complicated enough, that the default is that you get to choose, right? That's an extrapolation of what the FTC has already done on privacy, and I'm all in favor of having a federal law to do that, but it's not some radical break with how things have worked in the past. The key question, though, this is what I wanted to ask the panel before we move on, is in doing that. The approach in the past has been essentially we have this, it is sort of a common law approach, right? We work case by case. Mm-hmm. And importantly, and this is really critical in understanding how this all works, because the FTC, and for that matter, the baby FTC acts that the states administer, because these agencies have jurisdiction over essentially all companies, minus a few common carriers and banks, and they have these uniquely broad standards that are incredibly flexible, right? Deception, unfairness, right? The FTC, back in the Unfairness Policy Statement 1983, says Congress, and the Unfairness Policy Statement, Congress gave us this authority because they understood that we couldn't come up with a single list of all the unfair practices at once. So they wanted us to work this through over time. But the trade-off in doing that is the form of relief that's available. So there's a reason why the FTC doesn't have the ability to impose penalties for first-time violations of the FTC Act, right? And it's because of the uniquely complicated nature and unclear nature of the law, right? So we're not generally talking about fraud, where in actual fraud cases, you can go get your money back for consumers. Most of the time, we're talking about gray lines, right? So when Adam talks about permissionless innovation, it's really, it's not knowing where the line is to be drawn in the future. And so my question for the panel is, isn't that the right model to say that there will be lines drawn in the future, and we might have the regulators second guess where the line is, and they might say you drew it in the wrong place, and they might force you to redraw it and set a rule that once we've experimented that everyone else is going to do something differently. But it would be inappropriate for the regulator to come down with, let's say, hypothetically, a $3 to $5 billion penalty, as we're talking about now for Facebook, because you failed to draw a line in a very unclear area in the right way, or to hold individuals liable. Isn't that the right way to do this? And isn't that different from things like fraud, where we would hold someone accountable and say, no, you knew because that was fraud, that was clear. What do you think, Adam?
Well, I mean, generally speaking, I'm with you on this. The thing that I'm concerned about is that for each and every new emerging technology policy concern, we have some sort of like overbearing technocratic command and control like regime with an agency with the technology in the middle of its title trying to work out everything preemptively. It's better to have a more responsive ex post kind of an approach. It's a multi-layered approach. Let's go back to the cake layers and talk about like all the different things that you've already mentioned, like unfair and deceptive practices at federal and state level, tort law as a backup, and other types of laws and policies, in addition to all the soft law mechanisms. And to have that as a more general purpose kind of approach to oversight or regulation, especially for general purpose technologies. This is why, generally speaking, I'm with you on what the FTC has done and continues to do, because it is more general purpose in character. And you can't find a more broad-based type of like regulatory approach than unfair and deceptive practices for commerce.
And why is general purpose regulation better than issue specific?
I think so. Now, not everybody agrees because they say that it doesn't provide enough clarity, right? And what my response to that is there's clarity we can live with and clarity we'd be better off without. Because if clarity comes in the form of a very micromanaged, technocratic, thou shall not regulatory approach, where you're constantly have to get a permission slip for everything, that's the death of innovation. That will lead to stagnation by regulation. What we need is an ex post kind of responsive approach that has a robust kind of not only unfair and deceptive practices, but like recall authority, the kind of thing that like NHTSA has, or other types of like things that the Consumer Product Safety Commission has for defective products and things like that. And we say, we evaluate these things one by one, case by case. And we have the tort law and a really healthy set of trial lawyers backing all of that up, saying we're going to sue at the first sign of trouble. That's not always perfect. There are liability questions there, but that is the superior approach, and that's the secret sauce that gave us the more entrepreneurial and innovative environment in the United States for the internet and many other technology sectors. While the rest of the world is more technocratic, by the book, by the code, everything's got to be preemptively regulated and spelled out.
And in the context of unfairness, which you raised, it's worth noting that there is an intelligible principle underlying that the Congress specified for the Federal Trade Commission, that the conduct that's for it to be unfair, it must be not reasonably avoidable by consumers, not have countervailing benefits to innovation, but when
actually harm them.
Right, and actually harm them. But then when Congress creates new agencies with specific power, it sometimes decides that it doesn't like those limitations. So the BCFP or CFPB, whatever we're calling it now, it doesn't just have the power to police unfair and deceptive acts and practices. It also has the opportunity to police abusive acts or practices, which is an area that hasn't been clarified through agencies issuing policy statements along the years. Spurred because of the idea that there has to be such breadth and such leeway for the regulator to ex post dictate whatever it wants to companies that there's no limit.
Okay, but so there are many instances where we have standards, right? So, the GDPR, in many ways, people misunderstand it. They think that it's extremely specific. In many ways, actually, it's about a series of balancing tests, right? Its requirement is that you decide, you do a balancing test, and then the regulator second guesses you later, right? The Obama administration, their privacy proposal, the 2015 legislation, was essentially two new standards, risk to consumers and respect for context. And they intended for those things to operate on largely a case-by-case basis, in addition to having some specific rules. How do we assess whether standards are good or bad? How do we know whether, how much of a burden to put on the regulated party? And how much does it depend on the potential harms at issue?
Everything. I mean, it all comes down to how you define informational harms or technological harms more generally. There's just no avoiding these conversations. And I think this is the problem we find ourselves in with this transatlantic debate about privacy, is that we have very different conceptions of what constitutes informational harms on either side of the Atlantic. And of course, here in the United States, our overarching information policy is driven by the First Amendment, and there shall be no law kind of thing, right? So we have a very different approach to information regulation writ large in the United States. And you can extrapolate from that the debates to come over things like AI, genetic editing, and all the other types of things that we've talked here today. I mean, there's every one of these, we have to get to the first principles, really hard question of like, what is harm? And I think that's the ultimate debate you can get. You have to answer these questions before you get to like, what is good governance, right?
Well, I want to move on to an issue that we haven't talked about yet. You mentioned Arizona as being a laboratory of democracy. One of the things that Arizona has done that is extremely interesting to people who care about the administrative state is Arizona last year, I think, became the first state in the country to, by statute, abolish what is called, at the federal level, Chevron deference, and to say that the courts are going to review what administrative agencies did de novo. They're going to look at the agency's interpretation of law and ask whether it's the right one, right? And that is a radical break from what the federal courts have done since Chevron was decided back in the 80s. It's very consistent in some ways with what Justices Gorsuch and Kavanaugh have called for. And there certainly seems to be a move to limit Chevron deference. And Kavanaugh, for instance, has said this is really about the separation of powers, and ultimately that the court's role is to interpret the law, and if they defer to agencies, at least on what he's called major questions, in fact, that was Justice Breyer's term back in the 80s, that really is an abdication of democratic accountability and the role of the courts in ensuring that what the government does is lawful. So is that the right way to look at this, and how does this connect to permissionless innovation? Ryan?
So even though Congress commanded in 1946 in the APA that the courts should set aside
Procedure Act.
that, yes. So even though the Administrative Procedure Act commands courts to set aside and hold unlawful agency action that's contrary to law, or arbitrary and capricious in practice when it comes to legal questions, as you noted. That's not what Chevron deference holds. So by revisiting that doctrine, it not only curtails the power of agencies to creatively chart their own regulatory voyage as technologies evolve, it also puts the onus back on Congress, which in a sense has been a willing partner in its own abdication of its authority. And in doing so, the result may be that Congress lets sectors remain unregulated for years or decades, perhaps as an intentional act, or perhaps because it can't come to an agreement about what regulation should look like. But that may, in many cases, be a more desirable outcome than giving agencies the leeway that they've enjoyed in many cases for a number of years.
But I think you need to take into account institutional competence and that there's a competition among regulators, right? So if you sort of strip or chill the activity of agencies because now we know that whatever happens, they're not going to be afforded deference, so they're going to move much more cautiously, then you may have more proactive actions by the state or, maybe by Congress and local authorities, right? So I think there is a question of, what can agencies do well? I'm thinking primarily of federal agencies, and what are they positioned well? Maybe what they could do better because they're not necessarily doing what they should, versus what's going to happen in other levels. Because the pressure is going to still be there to do something, and some regulator is going to take that up at some level of government or trial lawyers or somebody else. So I don't think it's a yes. I don't think it's should agencies be shut down? There's dynamic effects of those types of those behaviors.
Just make one brief point. I think we're going to have Q&A, so I won't leave time for that. But, the whole world of Chevron deference and the question of administrative restrictions is going to be kind of upended by what we were just talking about earlier about with the rise of soft law and more entrepreneurial forms of administration. In some cases, agencies are doing this quite intentionally to get around a lot of the Chevron deference. Now, there are other forms of deference, and Jennifer, my co-author in that law review article, she's writing a paper on this about Skidmore, Auer, and all that nonsense. But, we're going to have debates about deference in a soft law world, right? In a world more flexible governance mechanisms. What does it mean when Arizona did what they did? They created a state sandbox for fintech entrepreneurs to come in and talk with the agency officials about how to carve out a little more zone of freedom in Arizona. I don't know where the standing looks like in court on that. There's not a formal law for that, but there's a lot of interesting innovation happening in that.
Well, one last question before we go to the audience. So I'm as much of a critic of applying Chevron deference broadly as anyone. But I do think that the people who are pushing that have been, let's say, at worst hypocritical and at best naive in failing to understand that if the courts are going to scrutinize more carefully how laws are written, the laws are going to have to be written a lot more carefully and with a lot more detail. And it's ludicrous to expect that Congress is capable of doing that in a world where you have, just for example, you might have a subcommittee that oversees the CFPB, the Federal Trade Commission, the Consumer Product Safety Commission, with 2 minority staffers and 6 majority staffers, and they're dealing with thousands of agencies. Right. And I just find it just staggering that we still have, supposed free marketeers in Congress who pat themselves on the back for not spending every penny in their budget on hiring good and more staff. And we're not talking instead about having 10 times as many congressional staffers, so that the Article 1 branch is able to compete with the Article 2 branch. It just blows my mind.
Here's where we're supposed to put in a plug for renewing the OTA to make Zach Graves happy.
And it's not just about. There are many ways to do that, right? And even if you have some concerns about that, it just seems nuts to me that we're not everyone in this room doesn't agree that we'd all be better off if Congress had a lot more expertise and ability to do things. And that, to me, some people might say, well, that's technocracy. I think, well, that's just hiring competent people who can actually think carefully about what law is supposed to look like. And it's realistic that, law is going to be made by someone. So anyway, I want to take some questions from the audience before we run out of time. I think we have a question over here.
I've been a bad academic self-promoter, but I do have also an law review article on experimentation in regulation, so I'll tweet that out later. But they're actually doing a convening with the Administrative Conference of the U.S. and the Partnership for Public Service on May 30th. So if you're interested in that, come talk to me about doing
question
more piloting in government.
Over here.
I think in terms of trying to open up regulation to allow a lot of freedom, we should also look at the regulations that help those firms and say there's a balancing act. So the limited liability and access to patents, you're going to have the freedom to do things that might be dangerous and wait until the danger happens. Perhaps we shouldn't allow the patent. Perhaps we should take away the limited liability so that people have a stronger sense of the danger that might happen, rather than get the advantages of the regulatory system that now protects these firms.
Quick thoughts?
It depends on the application there about what kind of liability things we're removing. If it's something like 230, I'm against removing those liability protections, but it depends on context. But I agree it is complicated. I will say this, that we, again, have a very healthy set of bar lawyers in this country that sue at the first sign of trouble, and that doesn't seem to stop them in any context. In fact, we usually put laws in place to prevent overzealous forms of tortious liability in many contexts.
And the approach we take in some sectors, like the nuclear energy industry, where it's a hyper-regulated industry, but it also enjoys liability protection. You sort of get the worst of both worlds. A better outcome would be to have the industry responsible for its harms, and then allow insurance companies, in part, to play a role in regulating it, unless risks are extremely hard to predict, and the magnitude of harms is huge. There shouldn't be a huge governmental role compared to what there is now.
Right. The danger in this conversation is that people speak very broadly about liability, and the circumstances differ widely. So it's just radically different to talk about that in the context of websites, who they can't predict what all the billions of users are going to do with every piece of content. So let's not let anyone walk away with the idea that all forms of immunity are the same thing. Ian.
Yes, in the context of informal guidance, which we're seeing used at the federal, at the state level, are there any best practices that should be pursued in terms of promulgation or updating? I'm just curious about the panel's thoughts.
The Trump administration is currently looking into this, and this is something that's been on OIRA's agenda for a while. And so, yes, there needs to be more done to provide some oversight of the oversight process and of guidances more generally. Now, there are some who say we shouldn't be using them all because they're ripe for abuse, and there's certainly instances of that. Back in old traditional communications laws, Berin and I have written about, it used to be we called a lot of this sort of guidance and regulation a sort of regulation by raised eyebrow, right? And it was a real serious threat. It was a form of informal, indirect backdoor censorship. So there does need to be some best practices applied to this. One other thing I should mention is that there's actually an effort underway that Larry Strickling, who used to be in the Obama administration, has got through Internet Society to try to create some more formalized approaches to multi-stakeholderism and things like this for technology governance beyond just the internet. So I think this is the next generation of sort of entrepreneurial administration thinking, is like, how do you refine this process, make it better, make it more accountable, make it more transparent. Ryan and Jennifer and I in our law review article talk about some of those sorts of best practices that are needed.
I would add that even where the law doesn't mandate it, informal guidance should be the outcome of notice and comment processes.
And I would also say that I just think coming up with a vocabulary to talk about what it is, whether like what is a sandbox, what is a rigorous policy pilot, what does that look like, I think is really important, so that we actually have a set of, this is the definition. And so, I'm consciously using this practice, even if it's not APA sort of level rulemaking, formal or informal. But I think, we're all going to go and read that our law review article, a lot of us, and hopefully get that language under our belt.
Yeah, I just want to note that I see a lot of transparency theater in this area. Agencies will talk, about, they go out of their way to get public input. Federal Trade Commission, for example, has held, I think, 10 workshops over the last 10 months about how they should deal with a variety of issues. And yet the one topic that they asked about is the one that matters most. It's penalties and enforcement. And on that topic, they're moving full steam ahead with no public workshop. They took some public feedback, but they don't want to talk about what they're doing. And they're already making major changes to how they settle and enforce their authority. And they're just doing it, willy-nilly. And that seems to be a pretty common practice, that regulators will be transparent when it's least costly to them, and where they really just want to do what they want to do, they're going to make those changes in ways that are not transparent and necessarily visible. Any last questions, or should we just go back through the audience, through the panel, and ask you if you have any final thoughts? Colleen?
No, I think, to keep having the conversation, but, I guess the question is back to, the kind of momentum after this conversation on the panel. Like, is there a way to sort of get these practices put in, I don't know, through Lincoln, or is Lincoln committing themselves to doing more work in this area, or I don't know, just that's a question, I guess, for you, Ryan.
We're certainly interested.
Ryan, Adam?
I'll just say this is, a fast-moving pace sector, and that there's obviously going to be a lot of changes beneath our feet in coming years. I think the expectation that I think a lot of people in Washington have and a lot of academics have is that there's going to be a great deal of certainty in this space and we can have a clear law and an overarching regulatory regime. And the thing that's so frustrating is that we'll never have that, but it's also the beauty of it is that we're going to have an inherent messiness to governance of emerging technology. And I've sort of made my peace with that after 30 years of studying this issue and realizing that there's sort of a method to the madness of that sort of informality or messiness, and it's actually yielding a lot of pro-innovation results, not always, but oftentimes. And so I think there's something to be said for the regime and the approach that we've got now, which is sort of quasi-permissionless innovation. I think that's the better approach going forward for most emerging tech.
Brian?
I think there may be some major shifts to the legal doctrines, both with respect to the state versus federal level and with respect to whether the Article 1 branch, the legislature, or the agencies make the decisions. And so this is a shift that may be foisted upon the technology world from outside forces that we'll have to reckon with.
Well, we haven't talked about this yet, but the thing that I worry about most is that all this this soft governance creates a perfect way for authoritarian governments to influence what media do. And that's incredibly disturbing, and we're already seeing evidence of that here in the United States and around the world. So on that note, thank you all. Thanks to our panel, and we'll move on to the next one.